This afternoon, we'll be discussing what hopefully will be a very, very engaging and topical issue for all lawyers in Nigeria. But just before we start, I would just like to give an idea of how we'll go about today's proceedings. We'll actually start with my review of the remuneration report. That will be followed by the review of the white paper issued on the remuneration report by the learned SAN, and he will also highlight issues or areas where they had a divergence with the Remuneration Committee. And then we'll take two sessions. The first on fees and charges, and the second on remuneration. We'll have a question and answer session of 10 minutes at the end of each session. So I ask that we all sit tight, and hopefully we'll be able to address all your questions on all the issues concerning remuneration as we know it. So if the organizers will please put up the slide, I'll start with the presentation, the summary of the remuneration report itself. Thank you. So obviously, as you know, we are discussing lawyers' earning capacity, a discussion on the NBA Remuneration Report. If you go to the next slide. So just by way of a background, the NBA president in his wisdom established a 15-man remuneration committee, which was approved by NEC on the 28th of February, with myself and Sheyi Olawumi as co-chairman. It was a 15-man committee comprising Reginald, who is also here. He chaired the subcommittee on fees and charges, and other 14 members cut across different demographics and the different geopolitical zones of the country. And I think it was important that the president considered this in establishing the committee, so that at the end of the day, the findings of the report would be representative of the thinking and the thoughts of all members of the profession, as far-flung as Kafanchan, and for those of us in Lagos or the big cities like Port Harcourt and Abuja. The overarching objectives of the committee were two, namely, to devise feasible ways to improve the poor remuneration of legal practitioners, and to design a workable and enforceable framework under which lawyers will, first, charge the right fees for their legal services using acceptable and realistic metrics, and ensure that these fees, when earned, trickle down in terms of reasonable living wages and emoluments to those who work with or for the lawyer. So in essence, I mean, the president in his wisdom felt, before we talk of remuneration, let's also talk about the earning capacity of lawyers. How do we ensure that lawyers, first of all, earn good fees, reasonable income, to enable them pay their workers or law firms? So the committee got to work, and it was divided into two subcommittees in line with the overarching objectives that I had mentioned. One, to deal with fees and charges, and the second, to deal with remuneration, essentially the wages you earn and your other conditions of service. And we adopted the following approach in terms of our methodology. We decided to ascertain and review all extant legislations relating to fees and charges and remuneration. So we said, let's even identify all the legislations, start with the extant legislations, and then review them. We also decided to carry out research on practices in other jurisdictions I mean, for example, for fees and charges, we reviewed practices in 6 jurisdictions: Ghana, Uganda, Rwanda, New Zealand, Australia, and the United Kingdom. So we also decided to gather and analyze relevant empirical data, and I would like to speak about this. For us, we said we had over time attempts by previous administrations to deal with the issue of remuneration. But I think the issue has always been that everybody spoke from their own perspective. And we said the best approach would be, let's gather empirical data. There can be no argument about that. And then proceed from that to determine what we think would be in the best interest of the generality of lawyers. So we decided to gather and analyze relevant data on subjects including remuneration and conditions of employment, living conditions, and the like. And in that line, we recommended a consultant who was a data analyst specialist to do that work. Obviously, we didn't have the capacity. And we also wanted the independence of the process. I didn't want Anthony Boche's views overclouding what the committee's work would want or any other person's own. So one, we wanted empirical data. Secondly, we wanted an independent process that at the end of the day will be above board and will leave no room for arguments. We received data from 6,000 respondents across branches of the NBA nationwide. 5,000 of them were via questionnaires and 1,000 of them via phone calls. The phone calls were decided because we knew that not every member of the bar would have access to the internet or would be able to work with a computer. So we said, particularly for areas where we think there was less internet penetration, that we should rather make phone calls and ask the same questions that were in the questionnaires. And thankfully, a lot of you responded, and I'd like to thank you for the cooperation we received in this regard. We also had 2 town halls. A lot of you participated. And in the town hall, we had speakers also representing different demographics and geographical regions, as well as speakers from other jurisdictions. For those of you who participated, you would recall that we had 2 speakers from Ghana and somebody who practiced out of the United Kingdom, just to give us the perspective of what happened in other jurisdictions. We had position papers and memoranda, and essentially had 30 meetings of the committee where we sat down to discuss about the issues, come up with a strategy, analyze the data, and eventually come out with a report, a 126-page report, which I'm sure most of you have seen. The report was divided into 2 sections, and including 4 appendixes, which were unanimously adopted and issued by the committee on the 24th of January 2002. Which was almost 11 months after we were appointed and got to work. Now, to fees and scale of charges. If you look at the report, the 5 top fee earning services by Nigerian lawyers, this is slide 4, please. From the survey we conducted, we noticed it was litigation, land agreement documentation, incorporation, debt recovery, and property management. While the 3 most popular billing methods amongst lawyers were identified as percentage fee, 44%, fixed fees, 33%, and retainers, 8%. That's the scale we saw up there in slide 5. We also observed that the extant rules governing legal fees are contained in or derived from the Legal Practitioners Act, the Rules of Professional Conduct, and the Legal Practitioners Remuneration for Legal Documentation and Other Land Matters Order 1991, which we call the existing scale. And overall, they recognize the entitlement of every legal practitioner to adequate remuneration and require that fees charged are to be reasonable and commensurate with the service rendered. It also particularly provides a non-negotiable guide on how lawyers should charge for certain matters, especially property-related transactions. And in essence, non-compliance is a professional misconduct for which a lawyer can be prosecuted before the LPDC. So that essentially is where we are today. Now, in carrying out our research, we want to know what were the limitations of these existing laws and rules in computing legal fees. And the survey we carried out showed that only 2% of lawyers in Nigeria, this is critical, comply fully with the existing scale. So it means only 2 out of 100 lawyers surveyed say they comply with the existing scale. So it means it's complied in essence in the breach. 21% said they have used the existing scale at some point, but not fully, while 67% said they have never used that scale. And what were the reasons adduced for this? 48% said that scale is outdated. Another 32% said it is never enforced. And 7% said it is complex to use. Another 13% said it is limited to property transactions. So, having analyzed all this, and having listened to you, who we surveyed, we decided that there was the need to actually work on the existing scale and come up with a new scale. So a new scale was drafted and recommended for approval in view of the agreed limitations which are already highlighted, and which was in line with the wishes of 93% of surveyed lawyers who said that the old scale should be reviewed, 93%, and 91% who felt that fees should be standardized. So 93% said review the old scale, 91% said our fees as legal practitioners should be standardized. So it was we as a committee eventually proposed that the existing scale as we have it be revoked. So some salient features of the proposed scale, which is to be cited as the legal practitioners remuneration and scale of charges order. Then we had said 2021, but hopefully if the NBA is able to move quickly on it, it will be 2022, it expands the scope of the existing scale beyond property transactions. It's tiered according to state bands. So different states will charge, each state will not charge equally, they will charge differently. With its bands to be determined by the LPRC, to which minimum and maximum fees will apply depending on the type of legal service provided and the economic realities of clients in such locations. So we felt that every region did not have the same economic strengths, and so the fee should not be the same per region. But the white paper remuneration, the committee chairman will speak more on this. And then the new fee sets out minimum and maximum bounds for legal practitioners with varying degrees of experience and seniority at the bar. So for example, a lawyer who's 3 years in the bar and a lawyer who's 7 years in the bar will charge differently for the same kind of matter. For property transactions, we essentially maintain the same computation, which essentially the way it works, as you all know, is that the amount chargeable reduces as the consideration increases. There are no bands based on experience of counsel like other fees, because as you all know that we commonly use standard agreements which are well known and widely available to legal practitioners, irrespective of experience. So, although at that time we had set maximum fee limits, we still did not prohibit charging beyond the limits in certain instances. And the conditions were that the legal practitioner discloses this to the client and takes out the professional indemnity in respect of that transaction. So at that time we had said if you wanted to charge above what was supposed to have been the maximum, you would take out indemnity and you would inform the client. An indemnity in respect of that particular transaction. So that way the client is properly informed of the proposed charge and can make an informed decision on whether to pay higher than the regulated rate for the service. Now to enforcement of the new scale. Well, we have discussed that the limitations of the existing one of which was that the centralized system of enforcement discipline that empowers only the LPDC to enforce the current scale without considering the frequency of possible breaches and the centralized nature and lack of institutional capacity and manpower in the operations of the LPDC. So really, how many matters can the LPDC take? So we felt that that was going to be a challenge. So to enhance easy enforcement, we made some recommendations, one of which was written terms of engagement. For every matter a lawyer takes, the scope of work and fees to be agreed in shall be agreed in writing before a legal practitioner commences work. For property transactions, we had recommended two options. The first of which entailed a lawyer applying the new scale to the transaction consideration. The fee is paid to the lawyer by the client, but the lawyer pays a percentage of the said fees to the local branch of the NBA. This was supposed to be a self-regulating mechanism to ensure that lawyers don't undercut each other. Because, I mean, if you are compelled to pay a certain percentage of the fee to the local branch of your local bar, it obviously will not be your own interest to undercut yourself. The local bar would now affix a seal on the document before you proceed to, with the perfection process. The second option involved actually paying the fees to the bar itself, your local bar. The bar will verify that the biller meets the request of the scale. MBA will deduct a fee and then remit the balance to the lawyer after affixing the MBA seal. The difference is that in option 2, the client pays the constitution directly to the MBA. That was the consideration. So we also consider the power to enforce the new scale and realize that neither the committee nor the MBA has the power to compel the use of the new scale. The Legal Practitioners Remuneration Committee, established under Section 15 of the LPA, is vested without power. If you read the LPA under Section 15, there's a Legal Practitioners Remuneration Committee, and that's vested without power. Now, the challenge with the current nomenclature is that the new scale would require the approval and adoption of the LPRC, which is made up of the Attorney General of the Federation as chairman, the Attorneys General of the states, the NBA president, and 3 other members of the NBA. And that committee, as far as we can remember, has probably not met in 10 years. So how do you deal with reviewing the scale of fees as you currently know it? So we don't think it will work under the current dispensation, where you have to go to that committee, which comprises all the attorney generals of the state and the attorney general of the federation. It simply is not workable if we are to implement this. So we have recommended that pending a meeting of the LPRC to adopt the new scale of charges, the NBA can recommend the new scale to lawyers for use as a suggested guide in determining their fees. So we know that from a legal standpoint, if we want to implement a new scale, we need to go and get the approval of the Legal Practitioners Remuneration Committee. But we're saying pending when that happens, we are suggesting that the NBA can recommend the use of the new scale as a guide to lawyers. Now, on the issue of remuneration, the survey showed that 29% of lawyers in Nigeria earn between 20,000 and 70,000 naira. 29%. 4% earn less than 20,000 naira. 23% have no fixed pay, meaning that their salaries vary per time. And only 18% earn above 150,000 naira. So, and the 20 to 70,000 naira band is mostly young lawyers of 0 to 4 years. Our extensive nationwide survey on the cost of living in different parts of the country, we undertook an extensive nationwide survey on the cost of living in different parts of the country using basic indices like accommodation, transportation, feeding, and basic utilities on a monthly basis. And just to know what the minimum spend of a lawyer in Nigeria would be. And it came to 89,600 naira. While the average cost of living in the different regions for Nigerians generally ranges from 84,565 to 144,091 naira. And the cost of living increases as the years of post-call also increase. And it varies from one geopolitical zone to the other. So in essence, many young lawyers do not earn what you would call a living wage as it is today in Nigeria. And I think that's a common knowledge for everyone. In addition, many law firms do not presently comply with several laws that impose obligations on employers to provide additional benefits, such as pension, healthcare, group life insurance, housing contribution, and even payee. We observed, however, in carrying out our research that out of over 15 countries surveyed, none except the United Kingdom has a regulated remuneration structure. So this is actually a novel issue. And one will tend to ask, why is it different in Nigeria? Why are we actually talking about remuneration? Why is the issue of poor remuneration endemic in our society? So, and even the United Kingdom we're talking about, the Solicitors Regulation Authority of England and Wales only recommends what law firms should pay their employees. Law firms are still at liberty to apply or reject the recommended rates. So this is actually novel, and I think it's because we actually have a serious issue on hand here. So, regarding the power to determine a minimum wage for lawyers in Nigeria, our research showed that there's no provision in the existing laws regulating the remuneration of lawyers in salaried employment, whether in law firms or corporate organizations. It's simply a matter of contract. And we can see that there's no other jurisdiction in the world that actually regulates a wage for lawyers. However, our survey indicated that 92% of lawyers want the NBA to fix a standard minimum wage. 92% of you said we should fix a standard minimum wage, while 85% of the lawyers were of the opinion that the minimum wage should be enforced with sanctions. So 92% said fix a minimum wage, 85% said fix a minimum wage and enforce it with some form of sanctions or penalty. So while the NBA is not expressly empowered under extant law to determine a salary scale for legal practitioners, however, as a self-regulating professional organization, we think it can make rules binding on its members as long as they are passed through the appropriate procedure and do not conflict with the rights of its members under the Nigerian Constitution or with the provisions of the LPA or any extant legislation. So quickly, some of our recommendations on salaries and emoluments. We have already talked about the need for the RPC, NBA to take steps to procure the amendment of the rules of professional conduct, and ultimately the LPA to make provision for implementation of the minimum wage as determined by the NEC. And it will be, even the one the NEC will approve will be on the recommendation of the Standing Remuneration Committee. In addition, we are saying that the NBA should make it compulsory for every employer of a lawyer to issue a written letter of employment expressly specifying the terms and conditions of a lawyer's employment, including salaries, pension contribution, health insurance, and other benefits. So we're saying every employer in Nigeria, and our labor law even talks of it, must have a contract of employment, written one, setting out the terms of his employment. What that does, the benefits of that is that it ensures certainty of terms. It will help check any infraction of terms stipulated or recommended by the NBA, and it will create a binding contract between the employer and the employee. We also have recommended that the NBA make it compulsory for law firms and employers of lawyers who do not have the minimum number of employees required to register with an HMO to register their employees under the hugely discounted health insurance scheme recently introduced by the NBA. So we are aware that the NBA provided a discounted health insurance scheme of about $15,000. Now, what we're saying is that if an employer of a law firm or a lawyer who employs lawyers says he does not meet the threshold to be registered with an HMO, he can simply come under the NBA scheme and actually provide health insurance for his employees at a discounted rate of 15,000 naira. I think anybody who has good faith, who wants to exhibit good faith, should be able to actually pay 15,000 naira for his employee or her employee. And we're also saying that make it compulsory for law firms and employers of lawyers who do not have the minimum number of employees. Okay, I've already said that, sorry. Now, coming to the wage itself, the minimum wage, we proposed a two-wage structure, what we call the standard minimum wage and then an alternative minimum wage structure. And we categorize them for states. So we noted from the survey that the uniform minimum wage for the entire country would not be practicable. I mean, we would not expect what a law firm or a lawyer in Lagos pays his lawyer to apply to a lawyer in some rural areas for obvious reasons. We grouped the states into 4 bands based on the data provided in the survey, on the current remuneration of lawyers in the geopolitical zones, their respective costs of living, and the economic viability of the relevant state. And we also created minimum wages for 2 categories of lawyers. The first was for lawyers between 0 to 4 years, and the other one was for lawyers between 5 to 10 years. In our thinking, any member of the bar who is above 10 years post-call has the capacity to negotiate better salary and working conditions for himself or to establish his own practice, and really does not require the protection of a regulated minimum wage. So if they put up slide 18, you'll see what the different bands, how we put the states in bands. There are 4 bands. For example, band 1, you see Abuja and Lagos. Band 2, you see Ondo, Ogun, Oyo, Osun, Ekiti. But the details of the bands are in the remuneration report, and which has been circulated. But if anybody still wants, if they reach out to us, we'll ensure to make that available. You can also see the next slide, the minimum wages for each band. So if your state, for example, falls into band 1, if you're 0 to 4 years, it's expected that the minimum wage should be 120, based on the survey we did on the what do you call it? Cost of living, sorry. So, and obviously Lagos falls here. Look at band 2, a lawyer of 0 to 4 years would be expected to be paid 112,000, while a lawyer of 5 to 10 years would be expected to be paid 146,000. And the same applies for band 3 and band 4. So there are two scales within that band, 0 to 4 and 5 to 10. And every law firm is expected to comply with this. But you must put it in mind that this report came out in February. Inflation has also happened after then. But I think the important thing is that we should have the will to start. If we're sincere and we have and we exhibit utmost good faith, the important thing is even the will to start in the first place. Now, the alternative minimum remuneration scale. What's the whole essence? Like I said, we took a survey of the entire country. We listened to what members of the bar were saying. And some people generally express the inability to pay a living wage, even if it was desirable. So what happened at the end was that we said for those who genuinely can't pay, what they would be allowed to do is pay 20% less than the minimum wage, but couple it with an alternative remuneration structure. That essentially means other means by which your employee can supplement that salary you're paying him that is 20% less than the minimum wage. So it applies to only those who are genuinely not in a financial position to pay the wage. So in addition to that 20% rebate, the employee is to be allowed one or a combination of the following in order to provide the employee the flexibility to generate additional income from other sources to sustain his needs. So it's one or a combination of the following, and I'll give you what they are. The first is that not less than 5% of the profit from the fees received from any work that is engaged on. So if you say, look, I am desirous of paying the minimum wage, I'm unable to pay it. We think that in good faith, what you should do is that any work that employee is involved in, undertaking, yes, you're saying on a sustained basis, I don't have that money to pay you. But when you get work, pay him 5% of that fees if you're showing good faith. In addition, not less than 40% of the profits on any work brought to the employer or the firm by the employee. So what we're saying is that if the employee also brings work to the firm, you should pay that employee 40% of the profits from that work. And these figures I'm giving you are minimum, and they have to be agreed up front and included in the contract of employment. Now, the alternative is that law firms or lawyers, in addition or in the alternative, law firms or lawyers who are not unable to pay the standard minimum wage may consider employing lawyers on a part-time basis. So the lawyers being employed will have flexible working hours. So for example, if you can't pay that minimum wage, you can agree with an employee, look, come 4 times or 3 times a week. If you do the math, and for example, the minimum wage should be 100,000, and you know ordinarily you should come 5 times a week within working hours, and you can pay 70,000, do the mathematics and let him come for the amount of time that ordinarily that prorated, that sum you're paying him as a salary would cover. So we're saying work out flexible work hours for that employee if you cannot meet the minimum wage. So in that instance, they will have flexible working hours and will not be required to provide their services every day of the week and for the full working hours of each day to enable them seek other fee-paying engagements. And separate from that, we also talked about pay per work. You can have arrangements where you pay the employees per work. I'd like them to quickly put up slide 21. Slide 21 shows what we had proposed as the minimum wage if you're paying an alternative remuneration structure, under the alternative remuneration structure. So if you're saying I cannot meet the minimum wage, I want to pay an alternative wage. In the first instance, we have proposed it cannot be less than 20% of the minimum wage. So, for example, if the minimum wage of somebody is 100,000, and you want to pay the alternative remuneration wage, the basis will be that you first pay 80,000, and then you work out an alternative structure with which that employee can augment his remuneration. And these are the various bands. There are 4 of them for the various categories of workers. So we've also said that the NBA should set up a standing remuneration committee, distinct from the one under the LPA, to review the standard minimum wage and an alternative minimum remuneration structure every 2 years and recommend changes as the need may arise. Now, we also discussed the issue of full-time lawyers in full-time employment, in-house and in civil service. And we received memoranda and papers from them, and we discussed that extensively. But we had an issue, and that was, we're also thinking about the end of the process. And the issue is that lawyers in government, or let's even start with those in the private sector. The question is that a lot of people raise the issue that their remunerations should be determined generally by what is applicable to the industry in which they operate. For example, my friend Reginald works with Chevron. And people might say, rather than us sitting down here, his employers and the MBA determining what his salary should be, it should be guided by what actually obtains in the industry in which he works. So what we also said for those in government is that the NBA should engage the government for special wage scale for lawyers working full-time in-house. Something similar to what the Nigerian Medical Association did for doctors who work for government under what they call a consolidated medical salary scale, CONMES. If you read it up, you'll find out that the Nigerian Medical Association years ago actually engaged government for the pay of doctors who work for government, and what they pay them is actually different from what their peers in the civil service earn, other professionals. The manner of enforcement, we recommended self-enforcement and regulator-enforced models. And for example, we just simply said, under the self-enforcement mode, employee lawyers are prohibited from accepting employments with remuneration below the standard minimum wage. And the breach of that thing will be a sanctionable conduct. So whatever one you decide to take, the minimum wage or the alternative one, as an employee, you would not be allowed to accept a salary that's below that scale. For regulator enforced model, we recommended that lawyers and law firms should file returns to their local branch every 6 months, confirming that they are in compliance, and also procure the amendment of the LP and the RPC to provide for the compliance of law firms and lawyers. Okay. So we also spoke about prescribing statutory punishment for breaches. We spoke about proposed amendment of relevant instruments should include sanctions for infractions by employers, such as payment of shortfall between the prescribed minimum wage and the actual amount paid the employee. And we also spoke about immediate steps that can be taken by the NBA prior to the legislative amendments, including procuring next approval of the proposed minimum wage and publishing same as recommendations from the MDA to lawyers and law firms, allowing a window for law firms to comply, publishing the list of compliant law firms, and commencing enforcement of Rule 13.1 of the RPC, which actually requires that once you start a legal practice, you should actually notify the MDA. We're saying expand that scope of that rule to include registration of firms and filing of annual returns. I'm sorry I took more time than I should, but the report was quite comprehensive, and I felt that we needed to at least touch essential aspects of it to inform the discussions that we'll eventually have. Thank you. So I'll quickly ask the chairman of the White Papers Committee to just give us a brief highlight of his own white paper.
Thank you, moderator. Good afternoon, everyone. And it's a pleasure to say a few words about this much talked about subject. I think the moderator has captured the essence of the conversation. And I think he was a bit modest in his description of the report because it was 126 pages. It's contained a very vast data obtained in the process, and it covered also a very wide spectrum of engagement that concerns us. There were two basic areas it focused on: the wages of lawyers working in law firms, and then the remuneration for fees in terms of fees payable for our legal services. Much of what he had said, we concord on the White Paper Committee with much of what the committee did, the area committee did on the report itself. I'll just quickly rush through the areas and the thinking that informed our concurrence or departure from what they had proposed. We agreed that it is commonplace that many lawyers are working in law firms, they don't even have a letter of appointment. They just were told, okay, come and start tomorrow, come and start next week, next month. And the day they want to let them go is just like, don't come again. And that is most unprofessional and unethical for us as lawyers. And so we agreed that all lawyers hired must have at least, even if it's just a one-pager, letter of appointment that will state the terms of that engagement. There should be something written. We also observed that from their assessment, most law firms are in default of all the statutory compliant mechanisms of states. There are laws that govern registration for health insurance, for pension, for tax, and several other responsibilities. Even there is a National Housing Fund. There are laws that govern these. And they prescribe a threshold of number of employees where it becomes compulsory for you to be enlisted. The least we can do as lawyers is to comply with the law of the state. But we also recognize that because of the multiple layers of compliance and the minimal number of, the minimal quantum of income, that there's some things will have to be done serially. And so starting with the NHS, for instance, just like the moderator has said, the structure that the NBA has put in place for 15,000 naira per annum, per person, is not with all sense of responsibility too onerous to be able to pay as part of the remuneration package of a lawyer employed. And so we accepted that recommendation that all law firms should, at the minimum, if we cannot meet if we do not fall within the threshold of what the NHS says for having an HMO, we already have a standard one with the NBA NHS scheme. The Remuneration Committee had mentioned the different bands of states, the divided states across several bands. And just for a quick look, Abuja and Lagos are in one band, and a number of other states, basically southwest and north central states, fall into the second band. And then most of the south states are in the third band. And then some of the southeast, northwest, northeast states are in the fourth band, based on the data of cost of living, as has been said. We accepted that as a realistic distinction in terms of the cost of living with respect to those various locations. We also accepted that, or before I run ahead of myself, let me say this with respect to the NHS scheme. It's not just for your lawyer employees. It's also for our non-lawyer employees. So it's not just that 15,000 for lawyers working with us, but even your law clerk, your secretaries, all of them, your dispatch clerk, they can also come under that. And we're encouraging that the same privilege be extended to them as well. We agreed with the state bands of the bands for the states for remuneration. However, we had a little bit of departure with respect to the alternative remuneration recommendation. We agreed with the recommended minimum wage for each state, but we asked that with respect to the alternative, where a firm chooses to adopt the alternative remuneration structure because the firm is unable to match the recommended minimum salary, that rather than 20% less, we recommended 30% less, and which was what was justified to NEC based on other realities reviewed together. However, we accepted that it must be with a combination or one or two or more of the recommended alternative options, which includes those profit sharing, appearance fees, part-time work, or personal client issues as well. We agreed with that. It's also without prejudice to a paperwork arrangement for freelance. There are law firms who have freelance lawyers. They are not their staff, but just someone that sometimes, it's not even part-time, so to speak, but someone that, you know, if you have work for me, your office is in Abuja, I'm in Lagos, send some work if you have in Lagos, that's freelance. So it's without prejudice to that. We accepted a few other things and made other additions. For one, in terms of compliance with these recommendations that have been approved by the NBA, when does compliance start? Whether it's going to be mandatory, whether it's going to be, well, it's not something that you choose not to participate. We're hoping that there will be a season where we can all co-own the resolutions and there will be no need for sanctioning people before they implement. But as a takeoff timeline, we had proposed, and it's accepted by the NBA, that the 1st of January 2023 will be a good time to take off. And that gives law firms, principals, partners to begin to plan towards it, whether I'm going full scale to the minimum structure or I'm going to adopt the alternative structure or whatever choice that we might decide. We also propose that the NBA will have the relevant protocols in place for the purpose of implementation. I'm sure in the course of the conversation we can discuss some of those probable protocols that the NBA might be looking at. We also talked about non-compliance. There will be 3 levels of compliance with anything we decide to do in life. There is a time when it is prescribed to you, go and do this. You don't necessarily want to do it. After a while, you look at the pros and cons, you choose voluntarily to do it. Right from when you were a child. Even as a baby, go and brush your teeth might be a problem. But when you begin to get older, nobody has to compel it anymore. You own it, even without any sanction. And that applies to every other thing in life. And so we're hoping that we can get to that stage that there will be voluntary compliance. However, we also recognize that not everyone will voluntarily comply. And that's not necessarily because the means might not be there. Some might have the means, but not just have the desire to go ahead and implement. And so it gets to a point that it can be elevated to a disciplinary issue. But even at that, there will still be multiple layers. For instance, in terms of compelling lawyers, law firms to comply, disciplinary committee that reviews such a complaint will give a prescribed period within which you are to comply. 30 days, 60 days, as the case might be. It's only after that and the individual or institution remains in default that it can then escalate to become a full-scale disciplinary matter. This recommendation was also accepted. With respect to our colleagues from the official bar, we recommended, and the NBA has also accepted this, that there should be a recommended minimum entry level for lawyers in the civil service, and it should be level 10. I know that there are a few states that already have that as the entry level. But from what I heard from a few comments, most are starting from level 9, which is like the professional entry cadre in most civil service of our states and the federal government as well. So we propose this, and we trust that the NBA can push this through in time to come. One of the things that we also mentioned with respect to the wages of lawyers is with respect to the need for it in the first place. We can't run away from the fact that we have a large population being churned out of the law school every year. If you keep having 6,000 people called to the bar, there are no guarantees there are 6,000 jobs waiting for the 6,000 every year. And in some cases, you have 2 sets being called to the bar in one single year. And so whatever wisdom that the Council of Legal Education and the Nigerian Bar Association will apply, there is a compelling need to also look at regulating the inflow and the output in a way that allows the market to effectively absorb what comes out. And this might not be peculiar to the legal profession. It might also apply to other professions. Now, the second part of it, in terms of what the committee report covers, is with respect to the charges for services rendered. And talking about services rendered, it's not just the documentation part of services, but every other service, including consultation or any other thing, legal matters in court, advisory, and all of that. And the committee had recommended a minimum and a maximum. We thought that we do not need a maximum. We only need a minimum scale of charges. Let the market decide the maximum. Irrespective of your age at the bar, you can negotiate what can be a maximum. But we agreed substantially with the minimum. The dichotomy that some other proposals in the report created with respect to litigation briefs, we also eliminated that from the final white paper, and that was with respect to whether lawyers in litigation matters had to disclose what they were earning in processes that they will file in a court. We thought that would be fraught with a bit of some ambiguity in implementation. And so we agreed with the minimum recommendation. And I know that it's in the report, but just as a way of, for us to just have an idea of what would constitute that minimum for various levels of services. So, also predicated on age at the bar, legal practitioners with up to 9 years post-call experience, for instance, for consultation, we'll be talking about just consultation is a minimum of 20,000. You can have anything as maximum. If you are over 10 years, minimum is 100. Senior advocates, minimum is 300. But not everybody charges consultation, so it's not compulsory. But if you do want to charge it, these are recommended. For legal opinions, for less than 10, 50,000. For 10 and above, 150,000. For senior advocates, 750,000 minimum. By all means, I know you charge more than that, depending on what you're expressing an opinion about. For incorporation, for less than 10, 50,000 minimum. And that's the lowest. I'm using the lowest band now. For 10 and above, 100,000. And for senior advocates, 300,000. This is just with respect to fees, not including your LCAC charges and stamp duties and stuff like that. Labor matters in terms of litigation, 200,000 for 10 and below, for less than 10, 500 for 10 and above, 2 million for senior advocates. Contractual disputes, 300,000 for less than 10, 500,000 for 10 and above, 2 million, and on and on. It also covers maritime, energy, and a band that we call miscellaneous, just in case there is a cause of action that is not captured here, but it is still a cause of action. You can always chat. Bail applications are covered, misdemeanors are covered, felonies, criminal trials, high court matters, court of appeal, Sharia court, customary court, Supreme Court. All of those are also covered in the same context. So I will pause here a minute because of our time. With respect to the property transaction time, the property transaction head of this conversation, the chair of the Remuneration Committee had elaborated a lot on that. There are one or two areas where we departed with respect to that, but that I will explain in probably a bit more detail when I have the next opportunity to chat with you. Thank you very much.
Thank you, Lelesean, for that concise summary of your white paper. We'll go straight to the other members of the panel, and I'll start with my immediate right, Dr. Reginald Aziza. Reginald, you were a member of the Remuneration Committee, and you chaired the subcommittee on fees and charges. So the question I have for you is, that's your new skill that you have recommended. How can it be implemented? What are the likely practical challenges in enforcement and implementation by the NBA and by practitioners? So what are the likely challenges that we'll have in enforcing the new skill? And are there any suggestions you have for the immediate implementation pending the legislation being passed?
Thank you very much. Good evening, ladies and gentlemen, distinguished colleagues. It's a pleasure to speak on this topic. As the chairman said, I worked as a member of the committee and chaired the subcommittee reviewing the scale of charges and remuneration that lawyers charge for their services. I think the question the chairman asked is in multiple parts, and because of time, I'll just try to speed through some of the thought processes there. In relation to enforcement, we must first understand where we're coming from. We're coming from a scale that was predominantly focused on property transactions, and we're moving into one that tries to simulate the wide breadth of services that lawyers provide to their clients. However, going by the empirical data we have, we know that property transactions and litigation form the two core services that lawyers provide to clients for which they charge professional fees. In relation to property transactions specifically, as the moderator mentioned in the review of the report, the system we are thinking about is one in which, having applied the scale, the client, and this is what was ultimately approved by the white paper committee chaired by the learned SAN on the panel, the client pays the fees to the local branch of the bar. The bar takes away a percentage for its administrative costs, and withholding tax is taken by the tax authorities from that. The balance is paid over to the legal practitioner. The key thing here, of course, is that you have to have a seamless process, leveraging a lot of technology. Because what we do not want is a system where, having made payments to the branch, bureaucracy within the branch then stifles implementation. So with that process, you have documents given to the branch. The branch is able to affix the seal to those documents. The critical thing is what we can do is to get the money into the hands of the lawyer by ensuring that the money leaves the hands of the client into some place, which is an account governed by the NBA. Now, when the monies are paid back from the NBA to the lawyer, ultimately, it's the lawyer's call what to do with that. And our hope and expectation, of course, is that we do not have a system where the lawyer, having received the funds back, enters a side agreement with the client where that undercutting continues, right? In relation to litigation, I'll spend a few minutes talking about this. And the reason I will is because I am both a provider of legal services to my internal clients, but very importantly for this conversation, I'm a consumer of legal services as well. And I consume services by engaging outside counsel who represents my interests in several places. One key way you can enforce a recommended scale for litigation is through the court process, through cost orders. Now, if you look at the civil procedure rules of various courts, take Lagos as an example, look at Order 53, Rule 1 of the Lagos State High Court Civil Procedure Rules of 2019. It says there that in fixing the amount of costs, the principle to be observed is that the party who is in the right is to be indemnified for necessary expenses for prosecuting the matter and compensated for time and efforts to come to court. Now, let's take a typical scenario. I have a matter before the Court of Appeal in Abuja, and I hire an SAN to represent me. And let's say I pay the SAN, this is just hypothetical, I pay the SAN 7 million naira. And the SAN, every time he or she is traveling from Lagos to Abuja for that matter, will have to fly business class. It's an SAN. We'll have to stay at the Transcorp Hilton. Has to travel with 2 lawyers, every single court appearance. We know that it's not a seamless process through that. You go to court the first time, the court's not sitting. Go to the second time, the matter is not on cost list. Go to the third time, you're able to argue an application. On the 7th hearing, on the 7th time, you're able to argue the merits of the appeal. Here's the problem. When that is all said and done, the Court of Appeal issues a judgment and orders 250,000 naira in costs. I have spent 10 million naira at that point. What then happens is very simple. When next something comes up, I ask myself 2 questions. First, do I need to vindicate this legal right in court? Bearing in mind that the monies I pump in are sunk costs to me. Secondly, if I think that I have to ventilate that right, why do I pay a premium? If ultimately I'll get 250,000 naira in costs, having spent 500,000, or having spent 10 million naira, I'm going to argue to pay you less. So what ultimately happens is, because the cost orders coming out of the courts are not reflective of actual costs spent, when lawyers are then billing for their services, the clients are more prepared to argue for less. It will be very different if I know that, per the rules of court, the expenses that I make, I will be indemnified for them. In which case, I'm happy to pay you more. Because at the back end, for so long as I know I have a solid legal case, I can claw back my fees, the fees I have paid to you. So I think in relation to enforcement in disputes, the courts have a critical role to play. I would finalize by speaking about what we can all be doing right now as we move on to this new system. I think law firms can and should commence the process of socializing what these changes are likely to be to their accountants, junior lawyers. Very importantly, trying to automate as much as possible the system for invoicing and billing, such that you could have a seamless system that applies the rules correctly and gets you the fees you want. Thank you very much.
Thanks, Reginald. Max, you've heard Reginald's own view.
It's not the judiciary of those things. We have to now.
You've heard Reginald's own views. So what are your own thoughts on this? What are the likely, how can we implement this new skill? Likely political challenges as a practitioner. And are there any suggestions for immediate implementation?
Yeah, thank you very much. It's a pleasure to be on this panel. And first of all, let me commend the moderator, Reginald, and everyone who was on the Remuneration Committee. When I read that report, I was really impressed. I mean, the depth of work, the depth of statistics that went into putting the report together is really wonderful. And I just pray and hope that our colleagues will accept this report and would all join hands together to get that report implemented. So the first thought I had when I looked at the report was I remember an incident we had in the Abuja branch in 2016. The branch came together and put together recommended scale of fees for the branch. But surprisingly, 2 months after, a colleague in the branch took the branch to court and said you have no basis because there's the LRP, the Remuneration Committee under the LPA has not authorized this. You cannot set a scale of fees. So there's going to be some pushback internally, I expect. But what I see about the work that this committee has done is because you have linked these two ultimate wages trickling down to lawyers, I expect that would create an incentive for people to actually buy into this system and make it work. For me, I believe at this point, law firms need to start looking at a couple of things to make this work. So I just want to address particularly what law firms should begin to do before 1st of January 2023 to get this to work. So the first thing is that as a law firm, you should have what my own law firm will call it a billing template. You could call it a billing manual or a billing guide, whatever it is. But it's simply a document that contains 1, the philosophy of your billing. 2, you break down the different routine tasks you typically have in that firm and set a band range so that for the associate who's working on a brief, if I tell him to come up with a bill, he knows what document to look at immediately and is able to at least come up with something, even if it needs the approval of someone higher up in the firm. So then also, law firms should begin to design things like fee notes and other documents that help in your billing system. Because sometimes what happens practically in my firm, for instance, is that sometimes you are in a hurry to get a client's job done. That whole administrative time to leave the legal work of drafting a brief to now go and start getting a fee note ready can be a little distractive. So it's just good to have these things ready at the tip of your fingers. Then also you need to run a retreat to internalize this new skill, and get people to understand. Then one important thing I think MBA can do for us, which is something that helped me when I started my practice. The New York Bar has a resource center where you can get a lot of documents, guides, templates, manuals, things like sample of employment contract and all of that. So the MBA could actually help to set up a resource center where people could easily go there and get some of these things in ready form where you could just pick a template and use easily. So that would also help law firms to get, running by 1st of January 2023. Thank you, sir.
Thanks, Max. I'm particularly interested in this your concept of a resource center, and I think it makes quite a lot of sense. Thank you, Max. That's appreciated. Leonard S.A.N., your white paper also speaks about MBA working in synergy with the tax authorities in trying to ensure that we don't undercut ourselves in charging fees. Because really, what's the essence of this entire conversation is that for a long time, lawyers have continued to undercut each other. We have skills, we set skills, but one lawyer down the road is always willing to take little or nothing for his work, thereby devaluing the work of the rest of us. So, Leonard SAN, when we talk of enforcement of fees on property transaction, what practical protocols do you think the NBA can put in place for engaging the tax agencies for the supervision and enforcement of recommendation in the short term and long term?
Thank you. Apart from undercutting by colleagues, one other challenge that we also see comes from the clients, and that is commoditizing legal work. When you get a letter from a bank saying go and do a search or go and do upstamping or whatever, and that same letter already says your fee is the X amount. What they have simply done is reduced whatever you are going to put into it by way of industry, effort, diligence, research. They have simply reduced it to a commodity not worth more than that fee. And so, to be able to ensure that we get value, it's important to not just get the lawyer doing it to have the understanding of what is being proposed, but also have an incentive that will assist in having an enforcement agency looking on what we're doing. Lawyers, and I'm sure we can't be sanctimonious, lawyers are one of those I've seen that are guilty of avoiding taxes. And so there is a standard tax, for instance, called the withholding tax that flows with these sort of transactions of documentation. But the taxman will never know of your transaction if you never self-report in these environments. And so the likelihood that they will say that tenancy agreement you did, that lease document you did, that property purchase you did, you have not paid withholding tax, the likelihood of anybody coming to you on that is low until things are automated to some extent. But because we don't want to get to that point, what we're proposing is to get your clients to pay these standards that we're proposing. It's best to bring in the taxman now. What you would have paid, you would have been paid 50,000 naira for. We have now proposed that you might be paid 250,000 naira for it. The only price you pay is that that money comes straight to an escrow account of the bar, and from that account, it comes in your name. It's your money. But from that money, the state tax authority will deduct its withholding tax from source. So if the client does not pay up to what is appropriate, he has to deal with the state tax authority who is looking for his withholding tax. And then the bar that's providing the clearing house takes an administrative charge. In the end, by the time you look at it, pros and cons, you are still walking away with over 200,000, as opposed to what you would have collected 50,000 for, even though you would not have paid tax on that. So rather than being penny wise, pound foolish, we thought that it's important to have this synergy. And one of the ways you can incentivize the state tax boards to come on board is because it's an IGR issue for them. This is IGR that they have never been able to capture, and suddenly they will be in a position to capture it. It's also a way to, they also build their data on taxable income anyway. And then it's for us, the incentive for us is that we get a lot more out of the same client that was unwilling to pay before we got onto this structure. So it's our hope that all of us working together, we will be able to find the common ground to effectively execute and implement this. Again, with respect to property transactions, particularly, one other thing that I think we ought to be also looking at is there are various genres of transactions, apart from lease, tenancy, and sale. Now that we see that in multiple jurisdictions there are condos coming up on the same plot of land, then you find out that the developer for that condo project has one legal consultant manning all of that. So you have 50 flats in one building. And so you're also going to be replicating these transactions in 50 places in one building. And so it's also going to free up a lot of monies locked up, a capital that has not been able to we have not been able to put to work, because it will generate fresh ideas as well. Once you know that there is already a standard template by which the fees will come in, and of course the states will be more willing to be able to even provide new things that they themselves had not thought about, once they see that there is an IGR element coming in for them as well.
Thank you, Lederson. I think he deserves a round of applause for that. Patience Udo, what are your own thoughts on what Lederson has just said?
Good evening, everyone. I'm always very reluctant to bring in the tax man. And I say this, it's not so much as seeking to evade, as what I've found out in this country at least is when you're captured into the tax net, those that comply are almost punished. I remember the first time I got my TIN number and all of that, we meet into FIRS. And then one day I come to the office and my junior says, they brought a note that I should come and pay 2 million. I say, for what? And the only reason they were able to do that was because we had come into the net. And a lot of the assumptions is that the clients will be willing to comply. There's such an unwillingness by clients sometimes to pay. I remember telling a client jokingly that he should bring his agreements. Maybe I wasn't joking, that was heart of COVID. And that I'll give him a discount. And the client says to me, oh, okay, there are a block of flats that are going up, but that you will sign that you've collected 10% legal fees, and then you get maybe some ridiculous token of maybe 25,000 for a legal fee that will probably be in the region of 750, 800. I said, don't worry, I'd rather not bother. So this is the kind of tactics that clients come up with to evade. I would rather suggest that we have a digital library. You know, like if you want to Google any company in the UK, all you need to do is go online. So if there's a digital record required, a proper one for land documentation, and then the requirement is payment of a specific fee, and that is part of what would then validate that transaction, I think we are better off lobbying to have those kind of situations whereby it is now part and parcel of legislation that is required. So those are my thoughts.
Okay, thank you, Patience, for your own contribution. For the purpose of time, we'll quickly go into a short 10-minute question and answer session. And we'll be happy to take questions from the audience if you have any. I think we'll probably take questions or contributions from 3 people. If you're asking a question, please limit it to 1 minute so that the panelists can respond. But if it's a contribution, please limit it to 2 minutes. Thank you.
Good evening, sirs. My name is Musba Adetumbi. First, let me commend both the 2 committees, that the review committee and the initial committee. But I'm just sharing a thought that I don't know, but I think it can be of help for us. First and foremost, how many law firms do we even have in Nigeria? Don't we need these statistics for us to be able to say, these are the people charging? Is it something that we can do where we can be able to identify law firms that are going to employ junior lawyers because it's easier to put figures on papers. But if you cannot really check whether there is compliance or not, I doubt whether we can really move forward. So I believe we should be moving towards even knowing ourselves. Know the number of law firms that we have in Nigeria, know the strength of these law firms, and be able to say, okay, this is our strength. Thank you, sir.
Thank you.
Good evening, everyone. My name is Mordecai Adejo, and I want to thank the both committees for the work they've done so far. But then I want to agree with the lady panelist on, and then also register my opposition to bringing in the taxman. Just like she said, I had my own experience where I voluntarily took myself to them, and then they started bringing ridiculous bills to me. I am not supposed to be paying taxes on everything I get. In fact, the withholding tax that were remitted to them by my client was more than what should be my own tax obligation for the year. But then they still go on making these ridiculous demands just because you brought yourself to them. And if you're looking for a TCC, you just have to agree to pay those amounts sometimes just to let peace reign. So I am scared of bringing them into this kind of situations, because when these people are seeing these monies coming in, which are our gross revenue, they are just going to get a lot of things over their head and start making demands, writing to us in ways that it might not be what the NBA intended to do. So that's my own contribution. I agree with her, and I think we should leave the tax people out of this if we really want to make this work.
The chairman of this session, my name is Nsikak Ikweme. I'm from NBA Calabar branch. I came to this conference with grief in my heart. And the grief was caused by an experience, in fact, two experiences I had. I did a transaction, documentation for a transaction amounting to 46 million. And when I asked for my fee, the person thought I was asking for an assistance. And I felt so angry. I said, why am I in a profession where my service is taken lightly? But I'm happy for this session because it's giving me hope that someday I will attend NBA conference in a first-class flight. Because if I had collected by at least 5% for 46 million, I would have stayed in Sheraton. One of the things that attracted me to this profession was the class. I had a few people in my community that were lawyers, and they were living good. And I'm asking myself, in my time, why is it like this? So with this, I think there is hope. And I am willing and ready to pay my juniors, but let there be a platform where I can earn better. Because if I earn better, they will feel better. Thank you.
Thank you. Let me just make a kind of contribution regarding what you just said. And I'll ask a question because I noticed a lot of people clapped when we mentioned the issue of tax. And I'll address this question to the speaker. Would you rather that withholding tax of 5% is deducted on your 5% of 46 million, right? But you're ensured that you will get it, than to continue under a situation where a lawyer down the street, because there's no form of compulsion, will take 400,000 for that transaction? What do we really want as a profession? You can't eat your cake and have it. We are talking about undercutting, and you're scared of the tax man. It's for this reason that you are opaque as a profession. That's why people treat you the way you are. Your profession is opaque. And I tell people, when lawyers always say they are scared, oh, they're going to know how much I earn. Oh, Everybody knows how much the estate agent earns for a property. Why are we scared of it? And yet we're complaining that we're not remunerated. They don't value our services. So either you can't eat your cake and have it. And we're saying to remunerate your employees, you must first earn a good living. For me, if I know I'm going to be paid 50 million on a 500 million or 100 million transaction, I will get my 10 million naira. Let government come and take 500,000 from the 10 million naira. But I don't want the next man saying I will do that same work for 250,000 simply because no taxman will ask him for his records. So we need to make up our minds, really.
Mr. Chairman, I am ready. In fact, when I campaigned twice for the office of chairman of my branch, one of my campaign points was that I want to make lawyers earn better. And in fact, in planning this, I had reached out to the IRS of my state and agreed and arranged on a way to make lawyers pay tax, provided they are paid their proper fees. So I'm not against paying 5% withholding tax to government. It will make me earn better.
Thank you. And just to the point, I didn't get his name in front. You mentioned about knowing how many law firms there are. In my presentation, I made reference to Rule 13.1 of the RPC, which actually requires that once you commence a legal practice, you should notify the branch. And we're saying that we should enforce this requirement. If you take your time to read that report, it's there. That requirement that you should notify them once you establish your practice, that we should start enforcing it. And that it should be expanded to include registration of firms and actually filing of annual returns. And the fact is this, I get astonished even in the course of doing this work when law firms tell me they don't file annual returns. But you're actually required to do that under CAMA. So really, I think we are part of our problems. We're the most opaque of all the professions. And we talk about the rule of law and justice and the like. You can't eat your cake and have it. For me, it's that simple. So I think the day we decide that we want to do what is right, we will get remunerated properly. If you treat yourself like what will I call it, a house help, the people you're dealing with will treat you in that manner. So I think it's a function of our mentality. We need to change it. And at the end of the day, I'll give you a typical example. Those who listen to the town hall, the Ghanaian law, you know what they said? They said prior to actually, that they actually fixed a scale in 2015 that they resumed recently. They said that today, if a foreigner coming to Ghana asks 3 lawyers for fees on the same matter, they will get almost the same thing. But in Nigeria, you will get from 20,000 naira to 50 million naira. So that's why we have an existential crisis. And we need to be serious about this thing. Thank you.
Thank you, Mr. Chairman. So we have 2 questions here. The first question is, Mr. Chairman, what exactly are the enforcement procedures the tax authority will employ to retrieve legal fees from a defaulting lawyer?
Maybe I'll let the white paper committee chair answer that.
Okay, and the second question is, I have reservations about using NBA branches to collect lawyers' fees. What happens if the chairman and the treasurer are fighting and cannot sign the check for the lawyer to collect his fee? What if the money is mismanaged? We hear stories of these things. So those are the 2 questions. Thank you.
Thank you very much. And those are real issues. And that's why we ask that the NBA, the national body, would design the appropriate protocol. Don't forget the account we talked about is an escrow account. So it's not one of those accounts that only the chairman and the treasurer will be the signatories. And the money in question is not the bar money. It's money belonging to you as the lawyer that did the work. And many other lawyers will have also their funds. It's an escrow account. It's a warehouse. So it's not going to be one of those accounts that only the treasurer and the chairman can sign. Yes, there may be There may be signatories pursuant to the Constitution, but there will be other signatories, including you, the owner, a representative of you, the owners of the money, as well as probably even the taxman. So it's not just going to be, I can just sit down and decide I'm not going to sign it for whatever reasons best known to them. But I'm sure the better wisdom as to the proposed signatories will come forth from the NBA. With respect to the enforcement, well, the same process by which tax authorities enforce against defaulters will be available. For instance, if they discover or you discover that having advised a client in respect of a particular transaction and expecting that the work will come, it will be billed, it got taken elsewhere, and somebody had undercut you and charged a pittance, you will report. You will report that transaction both to the taxman as well as to the bar. So the person who thought he was getting an advantage by collecting 100,000 for what you charge 500,000 for will still lose the benefit in spite of the fact that he has tried to steal a match. But if you choose not to report and just cover up your brother or your sister, then we're back to square one. So the obligation is yours and mine for us to ensure that you have billed a client, he feels you have overbilled, or he feels he cannot afford, or he will get somebody down the road that will do it for 10% of what you billed. He goes there, does it, you find out he's done the transaction for a pittance, not in compliance with the scale recommended. You have a duty to report. And once you do that, then it's not just a disciplinary matter against that practitioner. The taxman will still come after him, as well as the client.
Okay, thank you, Leonard Essien. I think I might take one more question because it seems this topic is quite, it's getting our attention. Actually, is there any more question? One more.
Let me start on the existing protocols. Aloyes and Lagos branch. Well, while appreciating the work of this committee, you've done extensive work, but I can still look at it as more of copying wholesale what is applicable in other jurisdictions. Because I look at what you have said to what is applicable in the state of Texas. Let me take example, Dallas. Now, but this issue of paying money to the branches, that's not how they do it there. Rather, what they do is that you have an account specifically made for that purpose for every law firm. If you are paid a check, you take in the check, you lodge it into that account, and then you now issue 3 checks. One check to the beneficiary, maybe if it's a litigation that you have won some amount of money, you pay to the client, pay to the local bar, and pay to yourself. So it's seamless. So, but if you have to bring in third parties, then the tax issues goes along with that because it is your income that is taxable, not the entire amount from the transaction. So I think we should look at that aspect of it and look at the way of adjusting it to suit that purpose. Not this. You've done very well. I must appreciate your efforts. Thank you.
Thank you. Thank you. I think what you have said is not so much removed. Like we said, it's an escrow account. The design is an escrow account. It's not a bar branch account. However, it's going to take more than that in this climb. We can't adopt what, as you said, might function in the state of Texas, for instance, because the reality on ground is that without the likelihood of sanction, you are not going to get compliance, not even from the client. In the state of Texas, there is the certainty of sanction, not even likelihood. So nobody will undercut. But in Nigeria, even when there is certainty of sanction, somebody still thinks he knows somebody somewhere. So you must have the force of that probability of sanctioning before you can, because the bar itself does not have its own power of sanction in terms of you still have to go through a government agency. And that's why we have to bring in that agency. And of course, piggyback on the fact that the transactions we're talking about already have a tax element called withholding tax. It's not a separate head of tax. It's the existing tax elements that should have ordinarily been paid on those transactions. So we just want a force that looks into it and ensures it gets done for the right amount.
Okay, Tito, quickly. Online questions.
Hello. I have one physical here. So it said, considering how privatized the legal industry is, what is your opinion on a pseudo whistleblowing in identifying defaulting firms, assuming this policy is implemented? So the person asking the question is asking if we have a whistleblowing policy in place as part of our plans for the committee.
Yes, it is part of the recommendations. And the idea is that the NBA should come with the protocols. But I'm also hoping that we can make recommendations about how they can actually put that into place. And that's actually why we're having this conversation. But whistleblowing is actually a recommendation for both segments of our report, both for fees and charges and also for the remuneration and conditions of service of lawyers.
Okay, thank you, sir. From the Hoover app, is there no way the proposed harmonized remuneration policy can be monitored by creating an obligation on employer to file statements showing pay slip? Also, let me take the second one at once. Would there be sanctions for lawyers? I think we've spoken about it, but let me just read it. Will there be sanctions for lawyers who deliberately charge lesser than required in order to beat competition and secure briefs?
Yes, there will be sanctions. There are actually sanctions in the extant laws. And it's deemed to be a professional misconduct for which you appear before the LPDC. So in the proposed legislation, that section of the act is also maintained. So there will be sanctions for breach of the new law when it comes into place. We need to quickly move on to our next segment, which is actually dealing with remuneration and conditions of service for lawyers in employment. And my first question will go to Max Ikongbe. Max, we've spoken about minimum wage and alternative remuneration structures. So what actions should be undertaken by the NBA for full compliance of the minimum wage and other conditions of employment, including penalties for non-compliance by January 2023? We've spoken about January 2023 being the date fixed for commencement of these recommendations. So what should the NBA start doing now for compliance, and any suggestions for immediate implementation?
Yeah, thank you very much. I mean, of course, I've seen a lot of questions online, and this is where it really centers. You know, how do we get these things to work? Because we expect to also see a lot of pushback when you say law firms must pay minimum wage. We expect to see a lot of our colleagues who run law firms to give some level of pushback. Now, the good thing about it is that we could we could set up mandatory enforcement requirements, but that would necessitate an amendment of the law. Between now and the 1st of January 2023, we don't have that leisure to get the law amended. So I'm going to speak strictly on things I think NBA can do to drive a voluntary compliance culture around this. Now, the first thing I'm going to say is that NBA must, first of all, internally do certain things to incentivize people to want to comply and pay a minimum wage or adopt an alternative remuneration structure. So, of course, some of the first things NBA has to do is to break down this report. Like I've said, have a resource center that breaks it down, what you need to do, how you need to go about it. The NBA ICLE should train on it. And then beyond just training, they could have video tutorials and like a resource center where these tutorials are there. You could always go back and review them. Then the NBA also should, through NEC, mandate all branches to discuss this report at 3 branch meetings between now and January. So if you have a branch meeting, you must set out 15 or 30 minutes to discuss it. You know, so just to ensure that it drives down to the branches. Then externally, NBA should publicize this widely. and let people know that MBA is concerned about law firms paying a living wage to its employees. Then MBA can also now get people like Reginald, who are external counsel. I believe you guys have the MBA External Counsel Forum or something of that nature. And tell them, look, no longer give retainership to law firms that are not certified by MBA as people who pay a living wage. Tell government agencies, tell other people who retain legal services that MBA now has, a condition. So that way, you make other people put pressure on law firms to do this. Then also, MBA can use carrot and stick to make this happen. One of the things I thought about MBA can use is MBA can register a certification mark under Section 43 of the Trademarks Act. That mark could be anything, but it simply says something like, I pay a living wage to my employees. So you can put that, when you write an email, under your email, the way law firms put, we are IFIL certified and all that. It's there. We pay a living wage. If you write letters, you put it on your letterhead paper, you put it on your website as well. But the backside of it is that certification mark, you must ensure that part of the rules that anywhere you put that certification mark, you put a link that people can go back to the MBA website to confirm that your website indeed fulfills the requirements. So it's not just hanging in the air. Then some other things MBA can do also is that with this certification mark now, the current law does not provide for filing annual returns to MBA. But MBA say if you want to be able to use the certification mark, you must file annual returns. So that becomes a voluntary but compulsory way without amending the laws. So if you want to benefit from this scheme and put this mark and tell people I pay a living wage, then you must file those returns to MBA. Then also that certification mark becomes, the last point, it becomes a yardstick for MBA to extend professional courtesies. You want to become a notary public, you want to get appointed, you even want to speak in the MBA AGC. Before MBA would allow you to be a speaker, they say, let us see that you are complying. If you are not complying, no speaking slot for you. So if you do that, that becomes a way to drive compliance and to ensure.
I see that this response elicited a warm applause. Let me even ask, when you talk of living wage, is there an on-living, something that's not a living wage?
Yes, so the wage that doesn't take you home. So at least this one will get home with you and at least help you half of the month.
Okay, maybe that's a purgatory wage for those who are Catholics. Thanks, Max, for that insightful contribution. I think there's a lot we're taking from this, and hopefully the MBA is listening attentively. Right now, you just heard what Max said. What are your thoughts on this?
It's difficult to add more to the contributions. But personally, and again, this is an issue that is very important to me. And again, I've had cause to write on this multiple times. And I've always argued that the way to achieve this is market-driven, not necessarily regulatory. So let me amplify just a little bit what Mark said about working with the Corporate Counsel Forum of the NBA or the Corporate Counsel Committee of the NBA SBL. Now, if you are able to convince in-house counsel across the spectrum, we will be able to see in a few minutes how you can expand this greatly. If you can convince them that you only retain lawyers and law firms that pay a living wage, then what it will mean is that off the bat, a number of people who do not meet this threshold cannot compete for certain types of work. So they, by themselves, put themselves in disadvantage. And there are companies that can do that. As an example, if you're able to get a bank, or all the banks, even better, to commit to that. You know that banks are present in every state of the Federation. And by definition, they have matters in every state of the Federation as well. So if lawyers have to pay a living wage to be able to access matters from banks, they are going somewhere. Same thing with state governments. The chief law officer of the state is the Attorney General. If the chief law officer says that we would only use that, both the state government itself and its ministries and agencies will only use lawyers that are compliant with this, you are going somewhere. Now, the way of thinking about this is, look at how, if you like, diversity and inclusion initiatives are driven in many businesses. They're not driven because of law. So think of a law firm abroad. That law firm probably has clients that say that the law firms that we hire must have at least 5% black partners. What then happens? That law firm has to go find them. And when you then go finding them, the question you have to ask yourself is, if I'm already doing this, I may as well do the best of it. So you have the law firm sitting in London that then comes into Nigeria and can poach somebody here, right? If you think about women in leadership, it's the exact same thing. The client group saying, we would only hire law firms that have at least 20% female partners. What happens in that universe? The law firm, again, goes out to comply. So if you are able to use in-house counsel, state governments, banks, those type of organizations effectively, you will get somewhere. And you will get that without touching a letter of excellent law. Thank you.
Okay, Patience, I hear you want to throw your own insights on this. 1 minute.
Thank you. I just wanted to draw attention to the fact that the people that are meant to partner to enforce are probably the greatest culprits. And I won't hesitate, banks. So most times, a lot of engagement letters come from banks. The fees are either fixed or they are solely based on contingency, which is almost like saying you won't earn. I have the advantage of having worked with several big firms before I started my own practice. So I've seen it from both ends. So major exchanges, they give you a letter and they say the fees are 2 million. Meanwhile, you're dealing with a law firm that maybe entry level is 120,000 and will probably have over 20 lawyers. And then you have a situation where they request for documentation for mortgages and a banker just sits down and writes 30,000 per search. A microfinance bank actually told me to conduct searches for incorporated business trustees at 5,000 and then one other one at 10,000. So this is the level of things we deal with. And even the oil majors, sometimes the reasons that some firms take work is because they're looking forward to get bigger briefs. Because if it's just that one, so is it these same people that will then have the moral, courage to help you? Thank you.
Thank you. For the purpose of time, I'll quickly go to the next question. Reginald, you may come back on that later. Let's see how time works. This question is for you, Patience, and because you chipped in on this one, I will cut your time to 3 minutes to respond to this. My question is, as a not so old, not so young principal of a law firm, what alternative remuneration structure would you implement for an employee if, for instance, you were unable to pay the minimum wage applicable for your location, and why? Any envisaged practical challenges?
Okay, in advance, I ask for more time. First and foremost, okay, I work in Lagos, so I've been running my practice for maybe about 7 years now. So, if for any reason I couldn't pay the minimum wage, I would say it would be on a pay as is received basis. And then I'll set up certain parameters, like health is non-negotiable, and I'm very pleased with the proposed NHIS scheme. I was telling someone that my private health insurance is about 120,000 per annum. I just paid a bill for support staff of 130,000. because there was no insurance in place for her to cover that scheme. So things like you pay the person's practicing fees, you pay for the person's stamps, all of those are what I'll consider. And then trainings. If there are trainings, they should be able to indicate interest, and if you can, some sort of subsidy on transportation. Now, the challenges are first and foremost the actual ability of the client to pay. Because, for instance, I believe that we don't have enough lawyers for a population the size of ours, but we don't have enough money to pay those lawyers reasonable wages. And so a lot of things that people should do for payment of legal services, they will not do. Now, COVID didn't help matters. The strike by the support staff of the court also didn't help matters, because during COVID, when courts were shut down, a lot of people turned to alternatives. A pastor will settle it. All of those incomes are shrinking. Let's not forget that if you look at the report, 64% comes from 64% of the people that are to bear this burden is my class of law firms. It's not the big ones. And also, the bulk of legal work available is first litigation and land transactions. So there is a genuine inability first of the client to pay. And then another very fundamental problem is how you receive the payments. So, for instance, I do an engagement letter. The client gives me a deposit of say 500,000. To get the other money is a problem. So, for instance, in my firm, I've had to pay juniors who have left, like some sort of bonus fee, because that is when the monies for the client comes. So what then happens is one junior is leaving, another junior is coming in. So if say two juniors are coming in and the work available at that time cannot fund it, it becomes a problem, because the person that has actually done the work is the previous person who has already exited the firm. So these are some of the challenges, and sometimes it's the timeline for payment. And then also, a lot of times the running expenses itself, it's a challenge. But let me not just look at the challenges. I would say that there are also things that we can do as for those that run the size of law firms that I do that can help too. You can expand your repertoire, and please run your firm as a business. The challenge a lot of small firms have is that they don't know what is expense, they don't know what is profit, they don't know what is overhead cost. So every engagement letter you issue should capture an aspect that is actually expense. It should be distinct, unless you have a special arrangement with the client. It should be distinct from the professional fee. And the expense element is not so much, if it's a litigation matter, it's not so much filing cost, transport. It is a prorated cost of the overhead as well. So that helps you to know whether you're being profitable in the first place. And also, get as much of the money as you can when you can, because once the client pays the initial fees like a spirit, once they've given you that first part, is either they want to trickle it or something funny. A client once sent me an alert and he goes like, "PP, have you looked at the alert?" I said, "No, sir." And he said, "Look at it." Why? Because he had paid like 1/3 of what was due, and he said in the alerts, at all, 9 bad pass. So these are the kind of challenges. But there is something that the big law firms can do. The big law firms have poached all the clients from small law firms. That's why we cannot pay. So this is what happens. A big law firm have bills that are issued running into hundreds of millions and sometimes billions for this transaction agreement. And so somebody comes and the person brings work to me, and I look at it, I say, okay, bring 5 million or even 2 million and bring 1 million on account of expenses. I have lost work to Magic Circle law firms in this country which are just about 10 in number. So what they do is they offer a lower rate, and then the risk and the actual expense of running that litigation cost is borne by the bigger briefs they have. The second thing they do it so that they can take these briefs for their colleagues who want to be partners, for their colleagues who want to make silk. So they are like, it doesn't matter whether we are earning, or the third category, they collect it so that people can learn on their mistakes. If we can at least censure, even if we can't enforce anything, if we can censure these big law firms, because for instance, during COVID, when things tightened even with the big law firms, what they did is they reduced the threshold more. So even when it's not profitable, so it becomes harder to expect us to compete in the same market. Now, a lot of average big law firms, maybe entry level is about 200,000. And when you look at their earning capacity vis-a-vis this.
Patience, 30 seconds.
Okay. Well, the most important thing.
And you've not told me the alternative remuneration you pay.
That's the first thing I did. You weren't listening. I can repeat myself if you give me extra time.
30 seconds.
Okay. Finally, until Nigeria as a whole improves, which is why we need to all be active, until things improve in the economy, that ability of people to pay isn't going to get better anytime soon. But I believe that law firms should be able to turn down work that is not profitable to them, so that medium and smaller sized law firms that are run in boutique style can benefit from this and pay. Now, Mr. Chairman, what I said as alternative remuneration, I said when it is earned, and that's why I articulated the challenges of sometimes how the money comes in. So when it is earned, you get paid, and then there are certain basic parameters which include your health, MBA, and training, and those are basics, and where possible, a transport subsidy. Thank you.
Thank you very much. Thank you very much. And I think that's why there's also the emphasis on when we also say we shouldn't be too scared of the tax element, because that issue you're raising about ensuring the critical element, and if you note, the work of the committee was first to ensure that the earning capacity of lawyers is enhanced. Because if not, there'll be no discussion about remuneration if we can't earn fees. And we need lawyers to stop undercutting that at the end of the day. My next question is for the learned SAN. As a former Attorney General of the state, the Chief Law Officer of the state, so you've been a government man, sir. What practical suggestions would you give for the successful engagement of government by the NBA for the approval and implementation of the proposed minimum entry level for lawyers in government? I think you spoke about level 10.
Yes, thank you. States have varying executory protocols. But one thing that is common to all state governors is that they are the fathers, so to speak, of all. And so as we speak about entry level for lawyers, we have to also recognize that the employees of the state are not only lawyers. They also have other professionals who also are entering into the civil service as well. And that means operating at the back of the mind of the chief executive of a state is, if I give you level 10, what stops the nurse also demanding level 10? What stops the engineer? What stops the education BEd person? What stops this one? Those are issues they will have at the back of their minds. So what do? What you do is maximize your own areas of strength. For instance, doctors, as had been said, have their Comcast wage remuneration scale. They negotiated it as a body with the NMA. And so entry level for doctors is level 12. And that's because of a number of parameters that they justified. One, the length of years of their training. It takes a longer time to train one doctor before he gets fully qualified. And he has not even talked of his what do they call that? No, even after housemanship is part of their training. The residency. We have not even talked of residency yet, which is another length of years of training. So with all of those justifications, they negotiated to level 12. What does the lawyer have to offer? Apart from our own length of years of training, inclusive of law school, as a criteria, we also had this morning, for instance, at the session, I was in one session this morning. Now, one of the risks that legal officers now face, particularly with the numerous jail breaks, is the risk to their lives. Because you have convicted X number of felons, and now some of them are on the loose. Is that not a risk? Even if they are not subject to jail breaks, they have members of the family. Those are risks associated with this profession that the engineer might not have, that the nurse might not have. And of course, they are also free to negotiate theirs if they can raise their own justifications. But the most important thing is that there must be a willingness to do so. A willingness to engage, not just as a union would make a lot of noise about it, but with some level of critical, empirical data that we can use to justify why should the entry level for a lawyer be at least level 10. If the rest of the civil service come in at level 9, then lawyers should be level 10. And what we have in Oyo State, for instance, is, it wasn't always so, but the entry level for professionals is level 9. But for lawyers, within a year, they automatically jump to level 10. They enter at 9, but within a year, they jump to level 10. There is no level 9 step this or step that. In between, they are moving to level 10. That was the negotiated performance that we have. But it's a start. So as we go from various states to another, we will have different parameters in terms of engagement with the chief executive and the level of cooperation you receive from the civil service. The heads of service will just stand against you and say you are just a civil servant like any other person. How do you have to negotiate your way through it? So we need to arm ourselves with some of these arguments when those kind of engagements start. And of course, now that it's a recommendation to the bar, the NBA itself becomes part of the voice that can back up those conversations.
Thank you very much. Unfortunately, we have exceeded the time allotted to us by 40 minutes. So at this juncture, let me actually thank all the panelists, Max, Reginald, and Patience, for what we will all agree has been a very, very, very intriguing session. I would ask that if we have any further questions, please send it to the organizers, and I'll attempt to have members of the panel respond to the questions. Thank you for the time.